Good morning, Your Honors. John Cunny on behalf of Jovan Adams. What we have here is a homicide. I assume you've read the facts. I won't belabor them at all. Where the evidence was that there were a possible number of suspects, including at least two individuals with whom the decedent had been actively involved in fisticuffs immediately prior to being shot. The principal evidence against Mr. Adams at trial was provided by his brother Josiah, who was 11 years old when he was first interviewed by the police, and I believe 12 years old when he testified at trial. He first told the police that one Takees Johnson, who was a co-defendant severed at trial, had alone shot the decedent, and which was consistent with at least one of the non-aligned witnesses. When I say non-aligned, there were two, I believe, neighbors who saw it, one of whom said that there were two people shooting and one of whom said that there was one person shooting. So at least initially, the statement given by Josiah to the police was consistent with one of the eyewitness, one of the somebody who wasn't aligned with either side. Thereafter, the police questioned him on two subsequent occasions.
So were all of them the occasions right near the time of the
first one? The first one was certainly near. The second and the third. Okay, I'm getting a little assistance here, Judge. The second one was also relatively close. The third one was not. Now, I don't know what the...
Am I right, the trial was about 2 years after the murder?
I believe that's correct. Now, what was the difference in time between the first and the second? I don't know, Judge.
I sort of remember it was months. It wasn't much, I think.
Yeah. It was... I don't believe it certainly wasn't a year or anything like in that order of time. Now, in both the second story and the third story, he implicates his brother, although there are at least potentially material differences between the two statements, primarily dealing with the clothing, because the clothing of the individuals was something that was for which there was evidence by the neighbor eyewitnesses who were not able to identify anyone. Now, at trial, Josiah then testified consistently with his first story to the police, and that is, he said that Takees was the one who shot. Now, he makes reference also to someone who ran away. That doesn't appear to be in his first statement. Now, whether that is an inconsistency or not, I'm not prepared to say. But certainly, in terms of who the perpetrator was, he gives his testimony is consistent with his first statement to the police. I'm sorry, Your Honor.
You finish.
Well, at that point, we get to the crux of the issue, and that is that he first was impeached with I believe the second story, at which time, by the way, the court gave an instruction about the use of impeachment testimony. I mean, the government makes the point, and this is just by way of sort of parenthetically, the government makes, when we argue later that...
the first one should have come in substantive.
Right, and there was no objection. That is correct. However, the court, I believe the day before, had given an instruction on the use of, and that's at volume 4 in the morning at pages 24 to 25, the court had given an instruction relative to the use of, for impeachment only, for prior inconsistent statements.
Is your disagreement with the substantive, is it that it wasn't formal identification, or that it wasn't, to classify this as identification testimony just is incorrect? This is his brother, and it's really I'm just not sure whether you are saying
I think it's both,
not,
Judge. I'm not making any. I'm not making any distinction. Certainly, in terms of the case law, you have to look at it as is it identification
because
testimony.
that's what the rule is about.
Because that's what the rule is about. Yeah, exactly. And obviously, this court in Lee changed the rule with respect to it changed it and said, okay, it can be introduced substantively. Now, and then after Lee, in Reedy, the appeals court addressed the specific issue that we raised, that is the distinction between an accusation and statements that are made pertinent to a formal identification procedure.
Isn't the Commonwealth correct, though, that in Lee what was really challenged was an accusation? I mean, in a sense, was an accusation. These are the guys. In other words, he said at trial, I didn't know who hit me or whatever, but the police testified. The police witness testified. No, he identified them as the perpetrator.
There always are statements that are made at a formal identification. At a formal identification. Sometimes it's just that's him. Okay, which is meant to mean that's the guy that did the shooting. Okay, so there's always an accusation. If there's an identification, there's a reason for the identification. That is, the identification is saying that's the guy. Now, whether there's also some other things that accompany that, if you look at, for instance, the Shaw, I believe it's the Shaw case out of the South Dakota Supreme Court. It was either that case. I'm maybe getting confused here. There was that case, and then there was the case out of Smith out of Florida. One or the other, and they talk about. There's actually a dispute between the majority and the minority in that, and one of the disputes is whether or not some of the statement was admissible and some of it not, because perhaps at an identification, a formal identification, there may be more things that are said that are not properly admissible as well. But that's not the question before the court. So to say that in Lee, that it was an accusation, it's always an accusation.
Well, when there's an accusation, isn't it generally true that the accuser knows the person who did something to him, and yes, that is part of an identification. Well, but it's really sort of more of a statement. Whereas if you shift over to an identification procedure, there's something that a little bit different going on. It may not be appreciably different, but
I suggest that it is appreciably different, and that's what for instance, to make reference. If I could back up, and I'm going to try to answer your question, Judge. I just want to back up a little bit here. What is it about an identification procedure that this court has said makes it appropriate for it to come in substantively? In other words, what is the distinction between it and any other kind of statement that is otherwise hearsay?
Right.
It's a verbal act.
It is. It's not just a verbal act, Judge. I suggest that it's the nature of the proceeding at which the statement was made. For instance, Lee makes reference to the fact that the statement is made, generally the identification statement at the identification procedure is made generally much closer to the event than is the trial. And Lee makes specific reference to the fact that memories can fade, and that's one of the reasons why this testimony is admissible substantively. The other, and if you look at the Shaw case, which analyzed Rule 801, which is the cognate rule that this court referred to in Lee, the federal Rule 801, and our corresponding sort of inchoate, well, not inchoate, but guide. Yes, thank you, Judge. They looked at it, and the analysis is that the legislative history of the rule made clear that it was intended to apply to formal identification procedures, and the Shaw court identified two factors, one of which I've already mentioned this court identified in Lee, and that is the fact that memories can fade. And the other reason that it allowed it is that absent evidence that there was a formal identification procedure, which has reliability, and this court has addressed that question as well. What is the appropriate way in which these identification procedures should proceed? Because there is an indicia of reliability in the process itself. So so the second factor that was identified is that there is something arguably suggestive. Well, not arguably, it is suggestive. Who is the guy? Well, the witness is looking. There's only one defendant in the courtroom, seated next to the defense lawyer. There's a suggestibility there that the prior identification procedure, to some extent, maybe that doesn't vitiate, but it to some extent alleviates that.
But had there been some relationship between the identifying witness that we're talking about and the defendant?
They're brothers.
They're brothers.
So, I mean, if it's an accusation and they know one another, why is it really an identification procedure? We have identification procedures so that people who don't know one another, you can test the reliability of that kind of imprint on the person's mind. But my God, when they're brothers,
well, but Judge, the question is, does that mean that it's reliable? What is?
Yes, it does, doesn't it?
Well, I'd suggest that it does not.
Well,
all right.
But you're saying it isn't an identification. I take it isn't an identification, and they're brothers. It's like any other statement where you don't get to have your inconsistent statement come in.
Exactly.
What's
the difference? What is the difference, Judge, between I saw the person, it's my brother, or
because all the scientific testimony about, or all the scientific studies about how people can remember faces and cross-racial identifications, how it's imprinted on the memory. Doesn't that all go out the window when we're talking about people that know one another so well because they're siblings?
So is then, Judge, if we take that to its logical conclusion, there should never be hearsay if people know each other, right. And I'd suggest that that's simply not the case.
But if you're right, and if we establish the rule you ask, that means that when somebody says that was my brother who shot them, then to accord with Commonwealth versus Lee, the police would have to say, well, son, I want to show you a photo spread, and I want you to identify the shooter. And the kid's going to say, he's my brother. And they're going to show him a photo spread. He's going to say, that's my brother. And now under Commonwealth versus Lee, that comes in.
Well, to some extent, Judge, obviously, the facts here, the fact that they're brothers is an undeniable issue. But it applies to everyone. To narrow it to this one fact ignores the evidentiary issue, and that is it appropriate even if they're not brothers? You can't make a different rule.
I understand, but in Commonwealth versus Lee, the witness knew the defendant, apparently not by name. But you're saying it would have mattered if he would have said, that was Mr. Lee. I know him well from school. We went to school together. I know him as Mr. Lee.
I suggest that it would, and there are certainly, the government makes the point in its brief that the majority favor letting in accusations as opposed to identification procedure statements made pertinent to, if I can, get that word out, identification procedures. And in fact, that's not the case. And our reply brief addresses that. There have been 4 courts that have, there have been, in our view, 6 courts and maybe 7 that have addressed this question specifically. Of that, 4 courts have said we're not allowing accusations. 2 courts, where are they? I got them written down here someplace. Yes, Washington and the Ninth Circuit say no, we're going to allow accusations, and probably the third just based upon a reading of the case.
But Oregon,
Minnesota, South Dakota, Florida make that distinction. It's
Right.
not a fake distinction.
But you've just told us it's a fake distinction because you say that every ID procedure is an accusation. They just
It
don't
is,
happen
Judge,
to know
but
the
it's in-
name
it-
of the person who they're accusing.
But it's in the context of a formal procedure for which there are rules and in fact the courts have looked at procedures to determine if those rules are fair or not fair. It's within a recognized procedure. Excuse me. Yeah, and there's a reason for those procedures. Those procedures are developed to make sure that it is fair. For instance, if there's a cross-racial identification, to make sure that it's fair, to make sure that the pictures that are seen are fair. Yes, if you want to make an exception, say, anytime the person claims they know each other, then we're going to allow hearsay, but if they don't know each other, we have to have the formal procedure. I don't think that makes sense.
But would it, in this particular case, if they had given him a photo spread,
Yes. It would have been in.
it would
at
have
least
come in?
Yes, and it would have been in the context then of a formal procedure. He would have been there. It would have. It gives a context. Who knows? Excuse me. Who knows whether he would have said the same thing? When given the opportunity twice, he said something very different.
I understand, but
isn't
when somebody says, I know somebody well enough,
He knew him well enough to say he wasn't him, too.
well, I understand that. I mean, there's certainly sort of credibility here, but the idea that when somebody says, he's my best friend from school, he's my brother, you then have to then show a photo spread in order to make it admissible, and we're going to distinguish the case in which that's done, even though it's a bit silly, from the case when it's not done, is a problem for us, because we're asking the police to do something that really is a little bit silly. We're asking them to identify his brother from a photo spread.
But isn't the other side of that, though, that if you say that the accusations of somebody who doesn't have any trouble identifying his brother come in under this rubric, it seems to me you may be saying that as long as you've got the witness on the stand, no matter what he said before he got to court, it's going to come in substantively.
Well, essentially
And so
that's
you've
it.
sort of
You vitiate
wiped
the
out-
hearsay rule. That's right. That's our position. And certainly in this case, but in this case that is not what happened as well, because the first statement did not come in substantively.
No, well, that's a different. Yes,
Yeah, that's
I
a different issue.
understand
Yeah.
that.
But that is precisely the point that we're making, and that is, are you going to have different rules? Is the hearsay rule going to be dependent upon whether somebody knows somebody or not? Did I know him well enough to remember that he said this? Did I know him well enough or did I know him well enough to see that it's him without a formal identification procedure? How do you, if there is a distinction based upon identification, what is the distinction other than the distinction that the courts have recognized, other courts have recognized, and that is it has to be in the context of a formal procedure. It has to. There is a certain. It's not just the process which is designed, and I'm suggesting it is greatly the process which is designed to ensure reliability, but it's also the witnesses is involved in that procedure as well. There is, just as there's a formality in a court, there's a formality to sitting down, looking at photographs, being told the person may not be there, this is it, what did this, etc. That is a very different process. And it ensures, and this court has recognized, that the way that process is accomplished can be unfair, or it can be fair because of the process itself.
Now, if you're right, do we have to reverse that part of Commonwealth versus McCoy in which we allowed the victim's statement to the sane nurse that the defendant was the person who raped her because she knew him?
Certainly in McCoy, this court allowed that statement. What I'm suggesting to you is that this court did not consider in McCoy the distinction that we're drawing here. Now, how you would deal with that jurisprudentially
Is our problem.
Yes. Thank you, Judge. But yes, I mean, I recognize that this court has allowed such a statement in the past. That is absolutely correct. But But absent, I'd suggest, the analysis that the court needs to undertake in order to determine why, if you are going to allow it, what distinguishes it from any other hearsay. And I suggest that there is no real distinction. And to make the distinction, because in this case they happen to be brothers, means that what about the next case? And you know, if you're going to have a different hearsay rule for levels of relationship, then there is no hearsay rule there either. I'm getting red lighted. So
that means your time is up.
I suspected as much, Judge. Thank you.
Thank you.
And obviously for the rest of for anything else, we rely upon the written brief. Thank you.
Good morning, Your Honors. May it please the Court. Elizabeth Kosterlitz on behalf of the Commonwealth. The Commonwealth would ask that the Court not limit the rule admitting prior statements of identification for several reasons. And if I could actually just start by addressing your question, Justice Botsford, about the statements and when they were made. The murder happened on May 16th of 2007. The first statement was May 18th. The second was on May 23rd. The third was on June 15th. And then the trial was on October 30th of 2008. So they were very close in time to the time of the murder. Secondly, just to step back a little bit and look at the development of the case law in Massachusetts about prior statements of identification, they have been admitted substantively under common law for a long time. So prior to Lee, the rule was only that the declarant, the person who made the identification, had to acknowledge that they had made the prior identification, and then it came in substantively. And in Commonwealth v. Reddy, the appeals court cited several cases where, you know, this court and the appeals court had allowed admission of prior identification, which was just the naming of a name, Jimmy shot me. Those were admissible substantively so long as the declarant acknowledged, yes, I made that identification. What Lee changed is that the declarant no longer has to acknowledge the identification. It didn't change at all what kind of identifications can come in. There was nothing in Lee that said, going forward, we're limiting it to only formal identification procedures. Presumably, this court in Lee was going to follow those lines of cases that had come before, admitting prior statements of identification that were the naming of the name, the so-called accusations.
But so what if you say here, my brother was there and he had on, I forget, it was black and white or something, I'm sure. That and testimony, he says at trial that my brother didn't take the train to New York, and then, but he has said before, yes, he took the train for New York at the time in question. I mean, why doesn't it vitiate hearsay completely?
Right, it won't, because it's non-hearsay only if it's a statement of identification. And the facts of this case, I think, are instructive in that the judge said it has to be very narrow. I understand that there was a narrative that Josiah said several things in the second and third statement, but you only get in the statement of identification. Defense counsel said, well, Your Honor, I'd like to get in all this stuff about what he was wearing, what Josiah said his brother was wearing or Takis was wearing, because that helps me, because he said different things at different times. But the ruling initially was it's very narrow, it's just a statement of identification, and I think that that's always going to be the ruling by a trial judge.
Yeah, but what if they hadn't been brothers? What if they were perfect strangers? Mm-hmm. And the prior statement was the person had on an electric yellow shirt with orange palm trees on it. Could that statement have come in as a statement of identification?
I would argue yes. I think that that's always something that's going to be...
Because that's the identification.
Yes. And again, going to my brother's concern about reliability, and he's right that in the very few cases that have limited the statements of identification to formal identification procedures, one of the concerns has been reliability. And I would argue, that a formal identification procedure, you can move to suppress. But I would argue that You can move to suppress any statement that you think, statement of identification that the defendant thinks was impermissibly suggestive. I didn't cite this case in my brief, but Commonwealth versus Oddware, which is at 429 Mass 231, in that case, he said you can move to suppress on due process grounds, saying that, okay, you saw a picture of the defendant in a wanted flyer and then picked him out, and that same picture was in a photo array. Well, you can move on due process grounds and on common law grounds. The Oddware says there are other grounds other than just the photo array was impermissibly suggestive. So defendant can always move to suppress on those grounds. There's always this, question as to whether the procedure or the circumstances of the identification were impermissibly suggestive. And also, as the Third Circuit pointed out in State v. Lopez, which is cited in both of our briefs, really concern about reliability, it goes to the weight of the identification, and that's certainly grounds for cross-examination. It was cross-examined here, and I think in any case where the identification comes in, the defendant is free to ask about the circumstances and see, whether it was a reliable identification.
So what is I'm struggling a little bit here to understand this change in rationale. Is there a change in rationale now that the court in Lee has adopted with regard to the admission of this, in the sense that initially, one could argue, Mr. Cunha does argue, that the reason why the court allowed in the earlier identification is that if it didn't, when the witness said that man did it, the jury is going to say, well, that's not very interesting. He's the only person sitting next to the defense attorney, so it's a very suggestive identification. Mm-hmm. And the court said, well, that they should understand that he did it much earlier and therefore should be allowed to testify to the earlier ID to make sure the jury understands this is not the first time he's done it. But here, the witness here is not saying that man did it. In fact, quite to the contrary. Mm-hmm. So what is the rationale now for letting it in? Is it purely because the government has witnesses who are being intimidated and needs it, or is there something that goes to its reliability, which is at the core?
Yeah, the rationale was two things in Lee, and this court noted. One, it was closer in time, is more probative. And actually that was in Commonwealth versus Day as well. This court said, closer in time is more probative. But in Day, the court said, well, where the identifier does not acknowledge the identification, the prior identification, that superior probative worth dissipates. And there was a concern about cross-examining and confrontation clause issues in Day. Then the U.S. Supreme Court decided Owens, which said, it's just an opportunity for cross-examination is all that's required. Then this court had the Lee decision, and said, it's still the earlier ID has superior probative worth. It no longer matters, looking at the federal cases, whether the person acknowledges the earlier identification. It still should be able to come in substantively. And this court specifically noted as a rationale witness intimidation, that there are outside pressures put on witnesses to perhaps change the identification that they made
any
early
testimony
in time.
of a witness? Why is identification? In other words, pressure on a witness seems to me isn't tied to the fact that he's necessarily to an identification witness. Say you found the gun, and the defendant gave you that gun. And that's what you could be, I'm just trying to see why this particular kind of testimony gets special treatment because of, and I see it in Lee. It's definitely there. That through bribe or threat to influence the witness to change his mind. But I don't understand why that's specific to ID testimony as opposed to anything else.
Well, I don't think it is. I think that that's just going on with the rationale that earlier in time is superior probative worth, that the identification made in court doesn't mean much. And so the earlier identifications have superior probative worth. And it's for the two reasons. One being, that it's not as suggestive as an in-court ID, and also that the person is less likely to have been subject to outside pressures. And the thing about the identification, prior statements of identification not being hearsay, is that it's a narrow exception. It's non-hearsay, but it's a very narrow statement. It's just, this person did it, this person shot me, or picking out of the photo, right? It's not long narratives.
But isn't there a difference, as Justice Botsford was I think suggesting, in a lot of these identification cases where people don't know one another, the prior identification oftentimes will be admitted because it was closer in time to the event, the person's memory was better then, it has probative value as a better source, perhaps, of identification because it was closer in time. Mm-hmm. It's more reliable. Whereas here, there's no question that the witness knew who his brother was. We're not trying to test his memory or test the reliability of an identification. What's at stake here is his motivation for changing his testimony. It's an entirely different purpose for the use of the prior statement.
Right, and this court, examined that in Lee, that prior to Lee's, prior statements of identification were admitted. Often, they were just admitted only for impeachment value, and then, unless the person I acknowledged having made the earlier identification. And in Lee, this court said, first, that's a false distinction, really, between impeachment and substantive admission, that it makes no sense to give this sort of limiting instruction when the jury is probably not going to follow it, essentially.
We have an awful lot of law that's based on that distinction.
Well,
however.
I agree, but that was one of the reasonings that this court articulated in Lee. And also that when the person who makes the identification doesn't acknowledge it, it doesn't mean that the superior worth has dissipated. And the court looked at all the federal cases, and I will note that I have not found any federal circuits that have followed this federal district court decision. All of this law, this distinction between accusation and identification, came out of this one case, which is United States versus Caquetash, which is cited in both of our briefs. It came out of the Eastern District of Wisconsin. It was a motion in limine that the judge was ruling on as to whether he was going to admit these prior consistent identifications. The judge in that case said, well, let's wait and see if the witness is going to make the identification at trial. And secondly, it's an accusation and not an identification, and it shouldn't be admitted. None of the circuits have followed it. Even the Seventh Circuit, none of the circuits have followed it.
I gather, I haven't read them, but Florida and South Dakota and maybe some other states have.
South Dakota has. That is one state that has said, yes, I think that there's a distinction between these formal identification procedures and other statements of identification. That's State v. Shaw. Minnesota, which is the Robinson case, which is the other case relied on by my brother in his brief, in that case, the court said there's a difference between an accusation and an identification when the people know each other. So in that case, it was a wife who had identified her husband as being the person who punched her in the face, told a nurse that, and then at trial said, oh, no, he didn't do it on purpose.
Yeah, under the federal rules of evidence, and I don't really know them, but under the federal rules of evidence, aren't prior inconsistent statements admissible for substantive purposes?
No.
Generally?
No, that's definitely been something that the committees have looked at as doing, but they're not. The rule is exactly the same as ours, that prior statements of identification.
No. A prior forget about identification. Yeah. A prior inconsistent statement, isn't it admissible for substantive purposes?
I don't think so.
Right.
No, and none of the circuits have ruled the prior statements of identification are limited this way. And in fact, the Third Circuit went the opposite way. State v. Lopez has said these kinds of identifications are admissible. The D.C. Circuit, I think, is the same, and the Ninth Circuit have all considered this. So
it just seems odd that we may have followed federal rules in Lee. We were persuaded by some federal analyses in prior inconsistent statements, and yet the feds are sort of swaying towards our law when there's a prior inconsistent statement involving identification. We seem to have gone in different directions for the wrong reasons.
I'm not sure I understand.
Well, I'm not so sure I understand it. I'll have to study what the federal law of impeachment is.
Right. Right, and I think that all of the, most of the federal circuits that have considered this are consistent with the Lee, or Reddy, the appeals court decision in Reddy, which is that these statements of identification that, this person did it are admissible under the rule. And again, I would point the court to, many years of decisions allowing this type of statement of identification in substantively.
But are they offered? Are they used in Reddy? Was the identification used in Reddy as a prior consistent statement?
No, there it was.
It was admitted substantively.
It was admitted substantively, but no, the person, the witness, did not. So in her prior statement at the scene of the crime, she said, my ex-boyfriend did it. Yeah.
All right.
And then at trial, she said, well, I saw his arm, but I didn't tell any officer that he did it, or if I did, I don't remember. So it wasn't consistent, and it was admitted substantively. And just quickly turning to the defendant's proposed rule that this statement be limited to the first statement of identification, I just think that that's a rule that perhaps was proposed on these facts, but in a broader sense wouldn't necessarily make much sense. For example, if in this case the first statement was inculpatory but the second statement was exculpatory, I think that probably the defendant wouldn't be proposing the same rule.
You wouldn't, assuming that we accept your view, the trial judge's view, that this that Josiah's second and third statements come in substantively, is there any basis not to have the first identification, if you want to call it that? Anyway, the first statement come in substantively as well?
No, I would agree that should have come in substantively. I will note, though, that the judge said, well, this is the first statement then I assume you're going to use for impeachment, and defense counsel said yes. So there was no motion by the defendant to have that admitted substantively. And I will also note that in this case, in the final jury instructions, the judge said, you can consider the statements where Josiah identified his brother substantively. And he had already given a statement about prior inconsistent statements only being limited to credibility, but he also gave a prior consistent statement instruction. So really the defendant got more than he wanted, because the jury could have used the first statement to impeach the second and third statements and used the first statement to rehabilitate his trial testimony. So given the instructions that the judge actually gave, the defendant got, I think, a benefit more than he could have. It could have created a substantial likelihood of a miscarriage of justice. Those instructions, those final instructions, are at trial volume 8, 68 through 70.
All right, thank you, counsel.
Hear ye, hear ye, hear ye.